Afternoon, Your Honor.
Good afternoon. Doesn't look like we have everyone here yet.
True.
I'm here. I don't know why my video is not showing.
Well, we can hear you fine, so.
Because this is so annoying because it happens I used it earlier this morning and I was fine.
Check your video settings in the lower left corner.
Yeah, it says select the camera and I have selected ASUS USB 2.0 webcam, which is the correct webcam.
Yeah.
So, and it just showed my picture before you guys came on. Let me see.
I think Zoom is officially overwhelmed at this point.
Here's Mr. Turk. What happens when you click on video settings? What does it show you?
Yeah, so then it shows me video and it does just show me black. It asks me if I want to touch up my appearance or adjust for low light, but I don't.
All right, well, I don't need you to appear visually as long as we can hear you. So Shannon, put us on the record.
Okay.
All right, this is a matter of Baker versus Keelhorn et al. Counsel, would you each state your appearance, please?
Good afternoon, Your Honor. John Turk on behalf of plaintiff Anthony Baker.
Good afternoon, Your Honor. Daniel Cortez appearing on behalf of defendants Dr. Monfett, Henry Ford Allegiance Health, and IEP.
And Your Honor, this is Loretta Subi for Dr. Keelhorn and Columbia Medical Center.
Okay, so we have two dispositive motions today. Mr. Turk, judging from your joint response to the two motions, since you didn't address the basis for the emergency room physician and the hospital, that you don't oppose that motion?
I don't have the goods to resist it, Judge. I can't stipulate to it for reasons I trust you will understand, but I also, as an officer of the court, cannot say that I have evidence to resist it.
All right, so I'm going to dispense with arguments on that motion, and I'm going to grant Henry Ford Allegiance Health and Dr. Monfett's motion. Mr. Cortez, you'll prepare an order to that effect?
I will, Your Honor. I'll have it submitted as soon as possible.
Okay, thank you.
Thank you, Your Honor.
Okay, and the other issue is whether or not plaintiff's expert who sufficiently matches the expertise of Dr. Keelhorn can testify to essentially cardiology type damages. I probably didn't state that very artfully, but I mean, that's really what this boils down to. I read both of your briefs. I'm assuming if there were a reported decision out there somewhere that talked about this very issue, one or the other of you would have brought it to my attention.
That's right, Judge.
Well, let me hear, Ms. Subi, why shouldn't I be able to accept plaintiff's expert, though, even though he's not a cardiologist, he is certainly trained to recognize and diagnose, even though he wouldn't be the one to treat it, he's able to diagnose cardiology complaints, is he not?
Well, Your Honor, it's more than that in this case. I mean, we're not talking about him just giving damage testimony. We're talking about him giving causation testimony. And we don't believe he's competent to give causation testimony pursuant to Michigan Rule of Evidence 702. And that's based upon Dr. Spengler's own testimony that he's not an expert in cardiologist, that he doesn't hold himself out as an expert in cardiology, that he's not a cardiologist, that he's not a cardiothoracic surgeon, and that he's first and foremost, as he said on page 19 of his deposition, a family medicine physician. And on page 17 of his deposition, he goes through what he does in a typical week, which is supervise a psychiatry residence in an addiction clinic, then see family medicine clinic, then see patients in the addiction clinic. Then he does teaching and research related to smoking. Then he sees diabetic patients, and then he does some more family clinic. He also noted that he has special education on page 23 of his deposition in special background in medical education, diabetes, hypertension, and hypercholesteremia. He's not a cardiologist. And one of the allegations in this case is that in order to comply with the standard of care, my family practice physician had to refer this patient to a cardiologist. And plaintiff doesn't have a cardiologist to say what they would have done had a referral been made, which is a big missing link in their causation testimony. But I'm not disputing that he gave proximate cause testimony as a cardiologist, but he's not a cardiologist. And that's by his own admission. And he doesn't have any scientific, technical, or other specialized knowledge that will assist the trier of fact to understand the evidence in this case in regards to proximate cause and damages. Plaintiff's only response on this issue is on page 4 of his response, where he goes, well, Dr. Spengler testified that family practice overlaps with cardiology, and he quotes part of Dr. Spengler's deposition testimony from page 52 and 53. But what Dr. Spengler said was, the crossover area is in asking an appropriate history. And I don't dispute that. I don't dispute that as a family practice physician, he can say what a family practice physician should have asked in suspecting congestive heart failure, or what questions a family practice physician should have asked to even get there. I don't dispute he can do that. But what I do dispute is he can't say what a cardiologist would have done had this patient been referred to a cardiologist. He can't say what an echocardiogram would have showed because he doesn't read echocardiograms. He can't say whether surgery should have been done sooner than it was done because he's not a cardiothoracic surgeon. He can't say what the difference in outcome would have been, if any, if surgery had been done earlier because he's not a cardiothoracic surgeon. There's just huge gaps missing in the causation testimony. And I put those down on page 5 of my motion. Plaintiff doesn't have the necessary testimony as to what a cardiologist would have done had a cardiologist done a workup on this patient, as to how the cardiologist would have interpreted the echocardiogram, as to what the workup would consist of, as to what the result of the workup would have been, as to whether there would have been a different outcome or different treatment, as to whether surgery would have been different or the same, as to when this patient was a candidate for the surgery, and as to the outcome of the surgery. If a cardiothoracic surgeon testifies that this patient would have needed surgery in January, this expert isn't qualified to say that. And then there would have been no difference in the outcome in this case. In fact, he specifically testifies on page 171 of his deposition that he's not sure whether surgical intervention would have been needed, at what time it would have been needed. I mean, he does give causation testimony. I'm not disputing that, but I'm disputing that he's not competent to give cardiology and cardiothoracic causation testimony in this case. And
So let me ask you, have you identified or retained a cardiologist or cardiothoracic surgeon as an expert?
yes, we have retained a cardiologist as an expert. And
has that cardiologist offered an opinion that's at odds with plaintiff's expert?
well, plaintiff's counsel has not requested the deposition of my expert, but I can tell you that my expert has and will offer opinions at odds with what his family practice expert is saying.
So I want to ask Mr. Turk a question here. So putting aside for the moment your argument that your expert is sufficiently qualified because of overlap in expertise, even though he doesn't have the same level of expertise, he's certainly trained in matters concerning the heart and diagnosing them, even though he may not be trained in surgical intervention for those things. I'm looking at MCL 600.2169. And give me a second. I should have highlighted the section. Okay, I'm just rereading it to myself to make sure I'm in the right section. So right at the beginning, in an action alleging medical malpractice, a person shall not give expert testimony on the appropriate standard of care, of practice or care. Well, wait a minute, this is standard of care, and that's not the issue here. Give me just a second. It seemed so clear when I read it earlier, and now I'm questioning myself.
Your Honor, if I may, I think I know why you would have been looking at that section.
Well, what I was focusing on is if an expert witness is a specialist and is offering testimony on behalf of a party, that anyone opposing that has to have an expert with the same expertise.
Judge, that's correct insofar as it relates to standard of care testimony. That's the interesting thing about the medical malpractice statute. There's no question it does require a match when you have say a board certified general surgeon. If you're critical of such a physician, then the plaintiff's attorney must offer up testimony from a board certified general surgeon. There's no allegation in this case that Dr. Spangler and Dr. Keelhorn do not match. Ms. Subi's argument rather is that Dr. Spangler is not otherwise qualified to offer causation testimony, but the Michigan Medical Malpractice Act does not require to give causation testimony that a physician must match board certifications or qualifications. They must otherwise offer admissible testimony, which has a proper foundation. That's true for all expert testimony, of course. That's where the beef in this motion lies, I think.
Well, that's part of it,
Right.
Your Honor, but also part of it is that the standard of care criticism is that there was no referral to a cardiologist for a workup, and plaintiff doesn't have a cardiologist to say what that workup would have involved. And you're going to need, that would be a standard of care testimony. What would a cardiologist have done had this patient been referred to him? That's not something a family practice expert can testify, because why even refer the patient to a cardiologist if a family practice expert can testify to that area? And that's where one of the big gaps is in this case. To say the standard of care requires the family practice physician to refer this patient to a cardiologist, and then you don't have a cardiologist to say what the cardiologist would have done in the workup, what he would have found, what the treatment would have been done, what it would have gone from there, is a missing link in the proximate cause testimony.
So the proximate cause argument is because this was not, because a referral wasn't made then, and the plaintiff didn't actually end up seeing a specialist until months later, after the condition had progressed to a point that made it harder to reverse or harder to correct or less desirable outcome. Your point is, well, you need an expert to say that. I mean, yes, we can theorize that a delay in diagnosis could possibly result in a worsening condition. But what you're saying is you really need a cardiologist to say that that's the case.
Correct.
Not that it may result, that it did result.
Correct.
In this case, it resulted in a worse outcome. And only a cardiothoracic surgeon or cardiac surgeon would be competent to testify to that. That's your point.
Correct, because one of the claims, one of the approximate cause claims is that because this referral didn't take place, this surgery had to take place, but he doesn't have a cardiothoracic surgeon saying, well, if the patient had been referred to me in January, I wouldn't have done surgery. He could have been treated medically. He doesn't have that. So he cannot establish that there's a difference in the outcome in this case. I mean, there's, like I said, if you look on page 5 of my motion, paragraph 21, it sets forth the specific 5 things that he cannot show with this expert that he needs to show in order to establish proximate cause. And I mean, what I've written here is he doesn't have a cardiologist who will testify that more likely than not, had an echocardiogram been done in January and June, it would have been abnormal, prompting a cardiology workup, which would have resulted in the diagnosis of congestive heart failure. He doesn't have a cardiologist who will testify what the treatment would have been had the diagnosis would have been made. He doesn't have a cardiologist to testify that the patient's outcome would have been different had the diagnosis been made in the patient treated in January and June in relation to dilated cardiomyopathy. He doesn't have a cardiothoracic surgeon to testify that the condition of mitral valve with a left ventricle function and tricuspid valve, and whether or not the patient was a surgical candidate in January or June versus September, and whether earlier surgery would have changed the outcome. He doesn't have a cardiologist or a cardiothoracic surgeon to testify the extent of the valvular disease this patient had, and whether treatment or surgery would have been needed in the future, regardless of what occurred. I mean, it's undisputed that this condition was a congenital condition. So he has to establish that this patient would not have needed cardiothoracic surgery for this for this condition. And during the surgery, it was found that the patient had another valve that needed to be addressed, that had to be addressed surgically. So there is complex cardiothoracic and cardiology issues in this case that this family practice physician doesn't have the scientific, technical, or specialized knowledge to assist the trier of fact in determining these things.
Judge, that's just not accurate. Begin with the premise, begin with Dr. Spangler's testimony that there is much in family medicine that overlaps with cardiology. I have that quote on page, I'm sorry, I'm trying to scroll through my brief. Page four of my brief. It's not limited simply to knowing what questions to ask. Dr. Spangler testified later on in that page that I have quoted that the echocardiogram would have shown abnormalities if it had been done sooner. He was asked all sorts of follow-up questions about that. He testified that Mr. Baker's lifespan has probably been shortened as a result of the delay in diagnosis. He testified that if the diagnosis had been made sooner, his cardiomyopathy would not have been as bad if it had been diagnosed sooner. And he attributes specifically liver damage, kidney issues, fatigue as a byproduct of that cardiomyopathy. That's from pages 145 through 147 of his deposition transcript. And he uses this way of putting it in layman's terms, say that he uses the sort of 1 to 10 scale that he acknowledges is not the way you would ordinarily explain that or treat that in sort of a scientific way. But for a layman's explanation of it, he says that the cardiomyopathy on a scale of 1 to 10, say it was a 9 today, he said if his heart failure had been found sooner, he might still have had cardiomyopathy, but symptomatically the difference between a cardiomyopathy of a 3 or 4 is different than a cardiomyopathy of 7 or 8. That's reflective or reflected in his fatigue, his stamina, his focus at work. That's all testimony from Dr. Spangler. I don't question Ms. Subi's right to present the testimony of a cardiologist, a cardiothoracic surgeon, to testify that Dr. Spangler is just wrong. But on this record, Dr. Spangler, a physician of 30 or 40 some odd years of practice, who has experience with all of these things, and I grant, certainly not to the level of a cardiologist, but that's not an admissibility issue, that's a weight issue. It's simply not, redefining, moving the goalposts, as I think the defense does with this motion, is not what's appropriate. What's needed to satisfy the burden of proof on a motion for summary disposition is, of course, whether I can demonstrate a genuine issue of material fact with admissible testimony. And I would submit I've done that in the person of Dr. Spangler, who has also stood behind his affidavit of merit, in which he said that if Dr. Keelhorn had complied with the standard of practice or care, these heart issues would have been discovered much sooner than they were, and he would have received medical treatment, which likely would have resulted in a significantly better outcome than the one he has now. He can be attacked by cardiology testimony. I'm not questioning that, but it's not appropriate on a C-10 motion to dismiss the case on the argument that the defense has better qualified experts than Dr. Spangler.
Your Honor, that's not our argument. Our argument is 702. This court is a gatekeeper, and this court has to decide under 702 whether this expert has sufficient education, training, scientific and technical knowledge to assist the trier of fact in understanding cardiology and cardiothoracic issues in this case. And it is clear that he doesn't. By his own admissions, he doesn't. And again, it's plaintiff's burden to establish that he does. And the only thing that he quoted in his brief, and it's on page 4 of his brief, the only thing he quoted about overlapping is asking the appropriate history of someone who is describing difficulty breathing. He has not established any other overlap through Dr. Spangler's testimony, and that is insufficient to try to give causation testimony in this case as to what a cardiologist would have done had this patient been referred to him, as to whether a cardiothoracic surgeon would have taken this patient to surgery earlier than was done, and what the outcome would be done. Those are not family practice issues. Those are cardiology and cardiothoracic issues. And And Dr. Spangler, even at his deposition on pages 146 and 148, said, he goes, in general, a heart muscle would be better in June than in August and September, but he can't quantify it and he can't give specifics regarding it. He also said he doesn't know whether earlier diagnosis would have avoided surgery altogether. That's on page 56 of his deposition testimony. He is not a person who should be giving proximate cause testimony to assist a jury in a cardiology and cardiothoracic proximate cause case.
All right, I understand your respective positions. I frankly am in agreement with Mr. Turk that this goes more to weight than it goes to competence. So I'm going to deny the motion. Mr. Turk, you'll prepare an order.
Yes, I will, Your Honor. Thank you.
Okay, thank you. Have a good day.